And generally also we promote the cause of institutional arbitration in India, not per se SIAC, but institutional arbitration, as Lata and a few of my colleagues here have already mentioned. India isn't quite as advanced in its understanding of institutional arbitration as perhaps other of the more developed arbitration hubs in the world. And I personally do believe that that's something we should emphasize more on by drawing a comparison of how it works in an institutional structure and how it works ad hoc. Perhaps there are a few reasons why SIAC is popular amongst Indian parties. One of which is, of course, the fact that Singapore is a familiar forum to Indians. We share strong cultural ties. But apart from that, also the arbitral institution in itself and the rules lend a sense of faith in the way that they are structured and the way that the entire arbitration takes place. We pride ourselves in being able to complete an average arbitration between 9 to 12 months. If it's an overly convoluted one, it may take up to about 18 months. We also have special procedures, one of which is the Expedited Procedure, and that essentially guarantees that your arbitration will be conducted within a 6-month time frame from the time that the arbitral tribunal has been appointed. There are certain criteria, of course, that need to be satisfied in order to apply for the expedited procedure and for the president of SIAC to accept your application, one of which is that it needs to be under a certain value, so say the equivalent of Singapore dollars 5 million, or if it's agreed mutually between the parties, or if it's a relatively straightforward case. So any one of those, and you can apply to have your arbitration conducted under the expedited procedure. We've had about 140 applications so far for the expedited procedure, out of which 100 have been accepted because they've fulfilled those criteria. The second special procedure that we have is the emergency arbitrator procedure. We've seen 42 cases so far, or applications rather, for an arbitration to be conducted by an emergency arbitrator. All 42 have been accepted by the SIAC. We haven't actually encountered any trouble from the other party in complying with the decision of the emergency arbitrator, and perhaps that's because the emergency arbitrator's powers end with the emergency arbitration, and then the main tribunal is constituted. So perhaps the party that needs to comply with the decision doesn't want to seem overly controversial and uncooperative, because the remainder of the arbitration does still need to continue. We also have a panel of arbitrators of about 360 from 39 jurisdictions across the world. The way that works is that they are available publicly with their CVs and their qualifications on our website, and parties are free to appoint arbitrators from our panel if they wish, or arbitrators of their own choice. It is only where they fail to nominate an arbitrator and the nomination or the appointment falls to SIAC that we do so from within our panel. Otherwise, parties are free to choose an arbitrator of their choice. And then, of course, we would confirm it depending upon whether they have passed the independence and impartiality criteria of the SIAC. I'm open to questions that you may have, but I think I'll save the floor for my colleague who also has a little bit more to say about his institution. Thank you.
Thank you, Scheherazada. Last but not least, I now invite Aditya Korean from the Hong Kong International Arbitration Center to provide his perspective. Thank you.
Thank you, Axel. It's a bit of a strange position to be speaking from, but I'll try and amplify as much as possible. I won't say much about what we do, but I represent the Hong Kong International Arbitration Center. I'm largely going to focus my discussion on the theme for today, and just to show you how it is to be welcomed that the Law Commission of India has made some very significant proposals to amend the Indian Arbitration Act. But I also want to share with you how a jurisdiction like Hong Kong, which is actually one of the oldest, most sophisticated arbitral destinations in Asia, the HKISC, which is the Hong Kong International Arbitration Center, we're almost 30 years old. We started in 1985. And what really I want to share with you is the trappings of an arbitral center and what really makes it an international arbitration center. How has Hong Kong actually been able to succeed in that respect? And we can then compare the model to see how India can learn from a few of these things. Firstly, the government has taken a very proactive role in promoting arbitration, both ad hoc and institutional arbitration in Hong Kong. The Hong Kong International Arbitration Center, for instance, has been designated by the arbitration law of Hong Kong to be the default appointing authority. So what that means is if you have ad hoc cases in Hong Kong, where let's say you do not want an institution to administer your proceedings, but you seat it in Hong Kong, if one party fails to appoint the arbitrator, the HKIC will by default appoint that arbitrator. And if the number of arbitrators in your agreement or clause is silent, then the HKIC as a default appointing authority will decide on that number of arbitrators. But it won't do more but limit itself to these two functions. And this is to ensure that if parties want to go the ad hoc route, there is a strong system to support that. Because I represent an institution, I'm not selling the concept of institutional arbitration. You are the users, so it's best to you to decide which of the two options make more sense to you from a cost and time perspective. Second, apart from the legislative angle, the Hong Kong courts have been extremely supportive towards arbitration. They follow a pro-arbitration bias under the New York Convention, and that makes it very difficult for parties to set aside awards in Hong Kong. The Hong Kong Court of Appeal, which is the Supreme Court equivalent in Hong Kong, has actually gone a step further in addition to what the arbitration law in Hong Kong provides, is that if a party is unsuccessful in setting aside an award, it has gone ahead to award indemnity costs to the winning party. And that is a very fair decision by the court because, rightly so, a winning party should be awarded the entire cost of the arbitration, not just what was awarded in favor of him, but also the costs incurred by him in contesting that unsuccessful challenge. And that has led to a lot less frivolous applications coming up to set aside awards. And I think that is something that I think India can learn from to prevent recalcitrant respondents from bringing up frivolous challenges to set aside awards. I think if there is some sort of a legislative amendment or a decision by Indian courts to award indemnity costs. As my colleague here had mentioned, the emergency arbitrator provision, we actually were inspired by the Swiss rules, and we brought that into our rules. Again, to support the provision of emergency arbitrator and the HKIC rules, what the Legislative Council did in Hong Kong was to give teeth to the order of an emergency arbitrator, not just an emergency arbitrator who's issued the order seated in Hong Kong, but also the order of an emergency arbitrator seated outside Hong Kong. So they amended the arbitration law of Hong Kong to make the order of an emergency arbitrator as enforceable as a court order. Now, I've seen the Law Commission report, which has proposed that to promote institutional arbitration, there is to be some recognition given to the emergency arbitrator. But unfortunately, I think while it has gone to the extent of recognizing the importance of an emergency arbitrator, it seems to be the case where the interim order of an emergency arbitrator would be enforceable only if the arbitration is seated in India, because it doesn't expressly mention that interim orders of arbitral tribunals or seated outside India, or for that matter, interim orders of emergency arbitrators seated outside India would be enforceable. So I think that is a bit of a lacuna there, or maybe I'm not sure if it should have been thought of a little more, but I think if that was made a little more express, I think the provision of an emergency arbitrator would have been a lot more effective in India. And what I think India can do is the arbitration community here needs to take a more proactive role in training and setting up an arbitration bar. Partly why countries such as Hong Kong, Singapore, London have been very successful is because they have a very strong arbitration community, a very strong arbitration bar. There is not a very large pool of trained arbitrators in India. Most of them tend to be judges of high courts and supreme courts. Some of them tend to be very good, but most of them are not necessarily the best options. If you look at best practices in international arbitration, you find varied practitioners who are experts to partners of law firms, and even independent arbitrators. So this culture needs to be developed in India, and that would take away any mishmash of a court-related litigation style that merges otherwise into an arbitration procedure, which is entirely separate. So I'm very conscious that I'm running out of time, but I'd be happy to discuss any points that anyone wants to raise at this stage.
Thank you, Aditya. And you made several, of course, important points, as have made the others. But I will quickly pick up on one of them, namely precisely the issue of whether it's a good idea, so to speak, to hire a former judge to be your arbitrator. And I, from experience, can confirm it's not a good idea, because you get a sort of a variety of court case treatment, and that's precisely what you do not want to have. You heard what opportunities you have under the various arbitral institutions rules to dispose or have your case disposed of fairly quickly, even very quickly. So I think that is something, if I see the situation in India correctly, and Lata will, of course, correct me on this, I hope, something, namely, to shorten the disputes, the resolution process of your dispute. And also another problem, very specific, I think, to India, is you have this enormous backlog of cases. Is there not, I'm asking all of us and you, is there not a way to perhaps deal with it through arbitration? I mean, with existing matters that they will be given to arbitration. For example, labor. In many countries, labor is not arbitrable. In the United States, it is, and it's very successful. I think labor cases represent about half of the caseload of the American Arbitration Association, which is a very large institution. So there is this other issue, as I see it, how arbitration can help India to reduce the caseload that exists. Lata, you care to comment on it?
There's absolutely no question that, of course, if we encourage more and more of cases to be sent to arbitration, it's going to definitely reduce the burden on the courts. And like you said, it will be an excellent, ideal way of dealing with the backlog of cases that are there in the court. But the trouble with the arbitration is that the arbitral proceedings so far has been taking just as long as court proceedings, even though the Evidence Act and many of the Civil Procedure Code rules are not made applicable. In spite of all that, it went on and on and on, which is why now they've tried to deal with it by saying that the arbitral tribunal will have the same powers as a civil court in dealing with interim reliefs. So that's one way they've said that no court, but the arbitral tribunal will do everything that a court can do. And the point that you made about awarding costs to the losing party, they have done that already in the proposed amendment, and they've only said that while quantifying the cost, take into account these factors, and they've given a list of the conduct of the party, whether the counterclaim was totally unreasonable. But where a party has partly succeeded, even though not wholly, then they say that he's not to be burdened with that sort of cost. So there is a provision which is there in the Civil Procedure Code, but even more so in the arbitral proceedings. Now, one point which I missed out and which I thought you should know, and which I think some of our other speakers had said, was that the arbitration clause, how is it to be drafted? In India now, what they've said is because of the confusion caused by courts, they say certain provisions, like, for instance, an arbitral tribunal can take the assistance of the court for recording evidence. Now, when they say that, they say 27, some sections of the appeal to the Supreme Court. Now, what they've said is if the parties don't say anything in their arbitral agreement, in a foreign, arbitration clause, then they say that local, even domestic laws such as Section 9, Section 27, and 37 would all be applicable. So you'll have to be very careful and say, if you want to exclude the jurisdiction of the courts in India, say that we do not want the application of all these sections, and it has to be expressly said so. If the agreement is silent on these points, then of course the Indian law will come, and then you will have to brush with all the delays and everything else that is there in the court's calendar. Now, one of the reasons why, like you all said, your institutions are so successful because you have the choicest of lawyers opting to become arbitrators. In India, unfortunately, the kind of people who get enrolled, as arbitrators in institutions are of, I'm afraid, they're usually not very successful in the court, and they aren't known for anything special, expert knowledge or anything. So most people prefer then, in that case, instead of going to somebody dubious about whose reputation they're not 100% certain or whose expertise on the subject is not, clearly established, they would much rather then go and have an ad hoc arbitrator in whom they can repose faith, or take recourse to other arbitration institutions outside of the country. So we'll have to do something to have to improve the quality of people who become, arbitrators in that in the institutions. Thank you.
Thank you, Lata. Yes, Oliver?
Just with regard to speed, for large construction contracts, we have even gone a step further by having an adjudicator already during the course of the construction. So that is not something where you have a multi-party construction project going on, large. If the parties then agree from the very outset on an adjudicator, who is like an internal arbitrator, and the parties can, during the course of the construction, already refer cases to this adjudicator, and he then, if you, for example, go under the ICC rules for alternative dispute resolution adjudication, you have a result after 62 days. You have your first opinion, and although it's usually not binding on the parties, if one party rejects it, the party already knows quite clearly that his claim is not so strong or is very strong, and so you can start already from the very beginning of a large project to minimize timing and cost for later disputes. So you start with adjudication, and then on top of that, if you can't solve things within the adjudication, you can still later go to arbitration. But believe me, the pressure on the parties to put proper claims in place is very huge from the very beginning.
Thank you, Oliver. Anyone else care to comment on what has been said